Also very mindful of the question that Judge Reinhardt asked counsel for the school district was, didn't the parties, in an effort to finally get to the point where there would indeed be unitary status, figure out an expedited way to try and get there? The unitary status plan, which is substantial, does not set forth all of the particular plans and procedures that need to be put in place by the district in order for it to attain unitary status. What it does in Section 1D1 is say that there shall be a provision for the development of those plans, and then recognizing that we need to have those plans implemented if they in fact are going to get to the point of unitary status, sets an expedited procedure. The district proposes a plan, the plaintiffs respond, the special master attempts to resolve the issues, and then, if there are still disputes, he presents them to the court. Now, what the provision of the unitary status plan then says is, and this is important, the special master shall report such disagreements to the court together with his recommendation. It then says that the special master's report will include all of the attachments, and this is the submissions back and forth. Excuse me. And then most importantly, it says the court may order additional briefing as it deems appropriate. Therefore, to the extent that the school district in its visual tries to separate somehow or other the USP descriptions of what is to occur into a quote-unquote pre-R&R briefing and somewhere else a post-R&R briefing, that's simply wrong. Section 1D1 describes what is to occur before you go to court, and then it says to the court. The court may seek additional briefing as it deems appropriate. Now, interestingly, this is completely consistent with a provision of the appointment order that the school district neglects to talk about. The appointment order includes a very important section about what is to be done in circumstances in which the school district changes attendance boundaries, opens schools, closes schools, does the kind of things that have the most dramatic potential impact on the ethnic and racial composition of the district's schools. And what it says is a process that is virtually parallel to the process that the parties adopted for plans and procedures underneath the unitary status plan. In the order appointing special master, and I believe it's at ER 132, but it's in the section, it's page 3 of the order appointing special master. It says that the district will provide notice of a proposed closure, a building, acquiring new schools, changing attendance boundaries, and then says that the plaintiffs may object, that they have 20 days to do so, that the district then has 20 days to respond, and then upon receipt of that response, the special master shall make a report to the court. Period, end of story, except for one sentence, which is strikingly like the sentence in paragraph 1D1 of USP. The court shall thereafter schedule additional briefing or enter an order as appropriate. So once again, the package is put together by the special master. The special master sets forth all of the information and gives it to the court, and the court then decides if additional briefing is required. In response to an argument made by the school district after the court entered its December 2 order, that somehow or other the provision under 1D1, which again I emphasize is exactly parallel to the provision the parties agreed to in the appointment order, in response to a suggestion that somehow or other that violated Rule 53F because it didn't give notice and an opportunity to be heard, the district court pointed out that that was wrong because, in fact, everyone had notice of the process, everyone had an opportunity to have input to the special master, everyone had an opportunity to have everything go forward to the court, with the court then to determine if it was appropriate to have additional briefing. Now,
but the briefing is different from the creation of a record. So what opportunity do they have post-special master report to submit a record or make a record for the district court?
Well, I think the contemplation truly was that the process back and forth, and the process back and forth has been quite voluminous, would create a record, and it does create a record. In terms of legal briefing, the parties, in fact, have included some of that in their back and forth with the special master. And, in fact, to the extent there may have been something missing, that has now been remedied by the district court's order of December 20th on reconsideration, where he did say that parties would have 7 days to object. And to the extent that there was a need to make a legal argument, it is there.
Practically, opposing counsel said they had all these emails they wanted to file to make a record, and the district court said, no, you can't file those emails?
No, the district court, in fact, I was rather surprised when I heard that from opposing counsel. The district court has never said you can't file emails. The district court has never said that an objection is restricted to what is before the special master. In fact, what has happened with the submissions to the court is, let me roll back. The district court certainly did say that no court should be subjected to having to review dozens, hundreds of emails going back and forth. And this court may well remember that one of the district court's concerns, because it was cited in this court's opinion when it reversed and remanded, was that when it needed to make and determine what the record was at the last go-around, what it didn't want to have to do was run around in the record to see what was there. And the difficulty with saying we're going to file hundreds of emails is that that is, in fact, overwhelming. And
right, but at some point they have to have a right to create a record from which they can appeal. If the district court says, fine, we're going to resolve the injunction, or not resolve the injunction, and we're up here on appeal, they don't want to be in the position of saying we were denied the opportunity to make a record. So tell me how they do that, because it appears that under this procedure that if the special master comes up with a statement of fact to which that they disagree with, that they don't have an opportunity to contest that.
They now do have an opportunity to contest that because they have the 7 days in which to file an objection. The legal document cannot exceed 10 pages, but it can, and the record is full of instances in which it has been supplemented with declarations and exhibits. So there is the opportunity to make the record. I would also hasten to say that the court has shown a willingness to actually engage in de novo review when an objection has been made. In this context, with respect to University High School, the objection came up packaged in the report and recommendation of the special master because we were pre the 7 days for objection. And even in that circumstance, the judge knew that there was a dispute between the parties and a questioning of the special master with respect to his recommendation that the district not be permitted to put into place an untried motivational tool. What the district does not adequately state is that what the judge then did was to analyze the arguments before him in the context of the unitary status plan, because what he looked at is the unitary status plan, which in its discussion of University High School specifically says at excerpt of Record 75 that in preparing the admissions process, the district shall review best practices used by other school districts in admitting students to a similar program. It then found that this motivational tool not only was not used anywhere, but was untried. And it said, what the district said in its opinion at EOR, excerpts of Record 1920. It says, the district represents that the general consensus among the experts they surveyed regarding analysis of exam school best practices reflects the general consensus that the use of multiple and varied methods of analyzing students for the basis of admissions yields a more complete picture of the students and is deemed a best practice. So we're all talking best practices. We're all looking at the unitary status plan. The court then goes on to say, the district's UHS admissions process revision does not meet the best practices which are readily available from the survey schools for implementation in the district as recommended by the special master. So the district court analyzes the arguments, weighs them, does a de novo review. And in that regard, I think it's very important to stress that the district court is indeed giving the school district the attention we all believe is deserved in this very important case. And the suggestion made by counsel that the district is adopting recommendations of the special master on the day they're filed.
Are you talking about the district court? Because we have the unified school district. We have the school district and the district court.
The argument made by counsel for the school district that the district court is adopting reports and recommendations on the day they're filed is technically true in that the district court undertook to file the reports and recommendations because the special master does not have access to the electronic filing system. That does not mean that the parties and the court did not have the proposed report and recommendation well before the court ruled. The University High School ruling was December 16th. The report and recommendation is dated November 22nd and even identified as such in the excerpts of record filed by the school district. The report and recommendation on the discipline plan decided in an opinion dated November 20th, but filed with the court on December 2nd, was actually created and given to the parties in September.
How do we know that from the record?
You know it from the record because the judge refers to it as having happened in a December 2nd order, which we've put into the our supplemental report excerpts of record. I believe he refers to it as a November report elsewhere, but it's certainly a November 1 report, but it's certainly even by that reference is 3 weeks before the report and recommendation. The process, I think that's what the school district calls it,